All right, so this was after 12 hours of deliberation. The jury could not basically find him guilty here. They found him not guilty on first-degree murder and deadlocked on second-degree murder. The judge, as you heard, declared a mistrial there. So that was back in August. His sentencing will start tomorrow. With me here to break this all down, we have LaTonya Hines, prosecutor, and David Shapiro, criminal defense attorney, still with us right now. Guys, thanks for joining us. Let's talk about this Foley sentencing, because this starts tomorrow. And as I said, the judge declared a mistrial. So how does that play into when we have a sentencing phase coming up after a mistrial, David?
Well, I mean, what's interesting is to see what they're going to do, what, if anything, they're going to do with the second-degree murder trial. Obviously, it was resulted in a mistrial. So is that charge going to go away? Are they going to proceed as it intends that they are tomorrow with the voluntary manslaughter? At least out here in California, a lot of times what we'll do is we'll make that determination first, what's happening with the murder charge, and then address, obviously, the conviction. But what's interesting is the judge may, if she's inclined to get rid of or dispose of the second-degree murder charge, sentence Foley more harshly than she would if he was going to be retried on it. All those things factor into their decision as well as the prosecutor's decision.
Right, and LaTonya, weigh in on that as well. I mean, when you have a mistrial and then we're going to have this sentencing phase, do you agree with David with what he said on how this will play out?
I mean, I think that's a possibility, but I think at the same time, you have to evaluate whether or not you are going to truly do this retrial or not. He's going to be sentenced on this voluntary manslaughter charge, and so you've got to be able to go ahead and ask for the time that you would ask for that charge, because what happens if you don't go ahead and have this charge, the other charge, retried? There's always that possibility that you could retry it and he's found not guilty off of that charge. So you've got to go ahead and ask for what you really want on this voluntary manslaughter charge.
All right, we will see what happens. We're going to move forward now and listen to the prosecution's closing arguments from the trial. Let's watch. All right, so the prosecution opening arguments there, closing arguments there, basically they were saying that this is a premeditated killing. And we listened to that recording that you hear with the sort of raw emotion and the reaction to this when this is going on. Foley, I believe, had recorded a part of that, which is really interesting. When we have this recording coming from the defendant, how does that play into something like this, LaTonya?
Well, I mean, it could be two ways. One, it's you are part of doing your premeditation. The fact that you're trying to come up with a defense before it even the police even get there to be able to say, hey, this is why I'm doing this. This is why I'm recording it. It's very strange for somebody to go and record a situation like this. But the issue also, too, with regard to Foley is that he's somewhat believable, and I think that's what the jury thought. He seemed like this kind of innocent guy, and we heard Miranda testify, and she just came off kind of strange, and I think it's probably because she's had a very, very troubled life, especially this relationship she had with Jimmy.
Right, and now that we know, that the jury found him not guilty on that first-degree murder charge, and then, of course, deadlocked on the second-degree murder charge, and now listening to the prosecution's closings, what do you think that the jury had an issue with here, David?
Well, I mean, I was actually surprised hearing that 911 call, and obviously, as LaTonya just touched upon, the recording, there was definitely sprinklings there of premeditation. But I think that, whenever someone's making these accusations of someone sexually abusing somebody else, it sort of makes it's almost victim shaming in a way. And that's in self-defense cases. That's what the law pretty much allows you to do to a degree, where you could talk poorly about the decedent as justification of why you acted the way you act. And it's a pretty unique situation, whereas in other situations, the law protects the alleged victim or the victim of a crime, like in sexual assault cases. Here, you could bring in all this evidence about what he was thinking, what Foley was thinking, that led him to act that way. And while the jury didn't acquit him entirely, it's certainly something I'm sure that factored into the equation of why they acquitted him on first degree and ultimately could not reach a unanimous verdict one way or the other on second degree. Right.
All right, David, LaTonya, we're going to move on to the defense and their closing arguments. Let's listen. All right, so the defense's closing arguments there. LaTonya, what do you think the defense did well here that that obviously the jury did not convict him?
I think they hammered on the thing that no defense attorney, or no prosecutor wants, is an undesirable victim. In this case, that's what you have here. You have uncontroverted evidence that he had been molesting Miranda since she was a very, very young girl. And it was believable that, Foley was acting upon what he could have possibly seen. And then it almost kind of discounts a bit of Miranda's testimony, because this idea that she's had such a troubled relationship with this individual that she could be skewed in her thought process. And so I believe that they could believe him. And plus, he seemed believable when he was on the stand.
Right. And basically the self-defense worked here, David, right?
Well, it certainly worked as it relates to the murder charge. I mean, I tried a case here in San Diego, self-defense homicide case in August with my partner. We were able to obtain a not guilty verdict, and it was similar in the sense that, to a degree, like LaTonya was saying, undesirable victim, history of abuse that in our case our client knew about, similar to the gentleman here in Tennessee, and a real difference in strategy between prosecution and defense. Usually as defense, we're trying to cloud the waters and really focus on a tree here and there, and not really look at the forest. Because usually the forest is proof beyond a reasonable doubt for us in most cases. In this case, similar to my case, you get the prosecution harping on a lot of things, and the defense gets up there, and the defense attorney, that clip that we just saw, and he's calm, and he's talking about the law, and he's embracing the law, and he's asking the jurors to follow the law. That's a real unique case. A lot of times it happens in self-defense cases, and we saw an example of it right here in Tennessee.
Right. So interesting. All right. We got to take a quick break. When we come back, we're going to play the 911 call made by Foley. Stay with us after this.